Welcome to The Explainer. Today, we're jumping into a landmark legal case from the Philippines that asked a monumental question. Do we have the right to sue the government to protect the planet for people who haven't even been born yet?
This phrase right here is the heart of the whole thing. It's this idea that every single generation has a duty to the next one to preserve the rhythm and harmony of nature. So, who were these unlikely plaintiffs fighting for the future?
This wasn't your typical lawsuit. The people suing were fighting for a future they might not even be around for, challenging the actions of their own government in the name of generations to come.
So who were these challengers taking on the government? It wasn't some powerful corporation or a team of seasoned activists. Nope, it was a group of Filipino children fighting for a future that wasn't even theirs yet.
The main plaintiffs were a group of 43 kids represented by their parents. But here's the thing. They weren't just suing for themselves. In a pretty novel legal move, they filed the case on behalf of their entire generation, and get this, on behalf of all future generations of Filipinos. They filed a class action lawsuit with a really clear and urgent goal: force the government to cancel all existing timber license agreements, or TLAs, and just stop issuing any new ones. They wanted to, and this is a quote, arrest the unabated hemorrhage of the country's vital life support systems.
To really understand their urgency, we have to look at the environmental crisis they were staring down. This wasn't some theoretical problem. It was a full-blown catastrophe happening in real time.
So get this, just 25 years before the lawsuit, the Philippines had 16 million hectares of virgin rainforest. That's enough to cover more than half the entire country. But by 1987, satellite images showed a shocking new reality. Only 1.2 million hectares of that rainforest remained. That's a loss of nearly 93%. Just gone.
The scale of the problem was just staggering. The lawsuit stated that deforestation was happening at a rate of 25 hectares every single hour. At that pace, the country's remaining forest resources would be completely gone in less than a decade.
And this wasn't just about losing trees. The lawsuit laid out this terrifying domino effect of environmental disasters already being felt across the nation. We're talking everything from massive water shortages and soil erosion to the extinction of unique wildlife and the worsening of natural disasters like typhoons and floods. But when the children brought this crisis to court, they immediately hit a legal wall. Their plea to protect the future was shut down before it could even really be heard. The government's lawyers argued the children had no legal basis to sue. They claimed the whole issue of logging was a political question for Congress or the president to handle, not the courts. And they said that canceling the timber licenses would violate the Constitution. The lower court, well, it agreed on all points and dismissed the case. But the plaintiffs refused to give up. They appealed the dismissal, taking their case all the way to the highest court in the land, the Supreme Court of the Philippines. And that court would now have to answer some really fundamental legal questions. So first, the Supreme Court had to tackle the government's claim that the children had no legal standing. Could they really sue on behalf of themselves, let alone generations that don't even exist yet? The court's answer was a resounding yes. It found that their right to sue was grounded in that concept of intergenerational responsibility. It even stated that every generation has a responsibility to the next to preserve that rhythm and harmony for the full enjoyment of a balanced and healthful ecology. Wow.
Okay, next up. The court addressed the argument that these timber license agreements were basically protected contracts that the government couldn't just cancel.
And here, the court made a really crucial distinction. It ruled that a TLA is not a contract that grants property rights. Instead, it's just a privilege granted by the state, and a privilege can be revoked at any time for the public good.
Most importantly, though, the court declared that the right to a healthy environment is a fundamental human right. It's so basic, so essential to life itself, that it need not even be written in the Constitution, for they are assumed to exist from the inception of humankind.
The Supreme Court's decision wasn't just a victory for the plaintiffs. It set a powerful legal precedent that is echoed in environmental law cases all around the world.
So this single ruling established three revolutionary legal ideas. 1, it affirmed that a healthy environment is an enforceable right. 2, that citizens can act as guardians for future generations. And 3, that the public good can and should outweigh private commercial interests. The Supreme Court overturned the dismissal, breathing new life into the case. It ordered the lower court to proceed with a trial, now armed with a powerful mandate that affirmed the children's right to fight for their future.
The Oposa case literally transformed a group of children into giants of environmental law. Their initial victory in the Supreme Court didn't just win a legal argument, it left all of us with a vital question to consider. What responsibility do we owe to the future?